Welcome to InstaLegal. The topic for today's discussion is liability of father to pay marriage expenses of the daughter. Would this cover under the maintenance which a daughter who is unmarried can claim from her father? This has become important in lieu of the latest Delhi High Court decision, where the Delhi High Court has specifically said that the father cannot abdicate his own responsibilities to look after their unmarried daughters. He is obliged to take care of their children and other kind of expenses which include marriage expenses. The question which was faced by the Delhi High Court in the case of Poonam Sethi versus Sanjay Sethi was whether unmarried daughters who have attained majority and are earning their own income are entitled for maintenance and expenses towards their marriage. Now this question was discussed in view of Section 20 of Hindu Adoption and Maintenance Act, wherein the court observed that a father has a duty and an obligation to maintain his daughters and to take care of their expenses, including towards their education and marriage. This obligation is legal and absolute in character and arises from the very existence of the relationship between the parties. Kanyadan is a solemn and pious obligation of a Hindu father from which he cannot renege. Now the law does not give any provision which states that an unmarried daughter, even if employed and earning, be assumed to have resources to meet her own matrimonial expenses. Therefore, the court discussed Section 3B of Hindu Adoption and Maintenance Act, which provides a definition of maintenance, and that definition is inclusive of marriage expenses. Now, would unmarried major daughter be entitled to marriage expenses? The court answered in positive and said the maintenance as contemplated under the Act of 1956 is a larger concept as compared to the concept of maintenance under Section 125 of Criminal Procedure Code, and hence expenses for marriage are to be claimed in Hindu Adoption and Maintenance Act and not under Section 125 CRPC. Once any application for maintenance under HAMA is made by the daughter, that is maintainable even for marriage expenses. This was a bench of Justice Vipin Sanghi and Jasmeet Singh, and the court directed the father to pay a sum of rupees 35 lakhs and 50 lakhs towards the expenses of the marriage of the elder and the younger daughter. In the Indian context, the marriage of a son or a daughter would be expected to be performed in keeping with the financial and social status of the parents. This decision also becomes important for one more reason. Nowadays, the parties, the husband and wife, when they have a quarrel between each other, to show that they are not earning, they will not disclose their proper income in the ITRs that are filed. The court took note of that, and the court, looking at the lavish spending, etc., and the foreign trips made by the father, came to the conclusion that the father has a lot of economic sources which he has not disclosed. And the court said that looking at the financial status of the father, the court observed that his refusal to pay towards marriage expenses was most unfortunate. Now, the court also observed, and I quote, "We cannot close our eyes to the fact that both the daughters are, in fact, of marriageable age. The younger daughter's marriage is fixed, and the elder daughter will also require a corpus for her marriage. Finding that this fact is known to the father, the court granted the maintenance under HAMA." Thank you very much.